of the spear, cutting through the wrong. The swamp is thick, but the fire is strong.
All right, we're back. It's Sovereign Minds podcast. We need Mark to chime in, or what the heck?
Yeah.
Let's try it again. It's Sovereign Minds, the podcast. He's like, shut up.
He's like, I'm driving.
Driving. Leave me alone.
I got enough going on.
Enough of this foolishness. Let's move on to the serious stuff. All right. June 6, 2026. You're listening to Sovereign Minds. We're down here at Mountaintop Media in the epicenter of freedom. And this is podcast 171. We're not competing with Joe Rogan yet, but who knows? Maybe not. Just saying.
We just do what we do.
I don't know. We'll title it later. I got Shelby not being fringed. Can you hear me now? Can you hear me yet? I don't know.
Is it constitutional or not?
But we got Mark Baird with us, and it's getting interesting in the world of the Second Amendment defense of God. Maybe we should probably do a small walkthrough of how we got here, I guess, because it's a long, winding road, as the
It's been
Beatles
years
song
we've been
goes.
doing this. How long we been doing this, Mark?
Oh, it's got to be pretty close to 8 years now.
Wow.
Yeah.
Yeah.
No delays or stonewalling going on here, right?
No.
No, not much.
Jeez. So we started out, or you started out back in 8 years ago, whatever the day was.
Yeah.
And you said open carry is a right, or period, because there's no restrictions against it, according to the Second Amendment, shall not be infringed. Seems pretty plain, and you have the right to keep and bear, and I guess carrying means you're bearing, and so that seems to be a problem in California for a lot of different reasons.
Well, it wasn't until, what, the 60s?
Yeah, it wasn't a problem anywhere in the nation until probably the 1890s in a few places, and until well into the 20th century, and not until 1968 and 2012 in California. I mean, you could openly carry an unloaded pistol with a magazine in your pocket up until 2012, and children weren't terrified, and the fabric of society never unraveled, and the streets weren't running red with blood because people were shooting each other over parking places. None of those things happened.
You know, you'd think that people would wise up, that the Democratic strategy is always the doom and gloom report. You know, if we don't have health care, people are going to be dying. If we don't, we don't have people, don't get rid of the Second Amendment, there's going to be all this, chaos on the streets. If we don't,
if you don't transition your daughter, she's going to kill herself.
She's going to suicide. If you don't give us complete power, then the world's going to end.
Well, we have to be extreme on everything.
People are uneducated. They genuinely are, and I'm being kind here. I mean, they don't know where we came from. They don't know who we were as a people. They don't know why this government was founded. They don't know how it was founded. They don't know upon what principles, and even worse, they don't know how those principles benefited them directly and society as a whole. And so now they regurgitate the party line, and if someone who they consider their better tells them something, they just swallow it hook, line, and sucker. And that's kind of how we got here. And my question to the court is, do we actually have rights, or do we not? I mean, the Bill of Rights is very clear. The Constitution is clear, even though the state of California doesn't like it. So does the Constitution, do the Bill of Rights, in fact, supersede the wishes of local or regional politicians, or don't they? Do they broadly apply to the people of the United States who were born free and independent? In other words, we weren't born subjects of this government. We created this government. The government didn't create us. And when James Madison sat down to write the Second Amendment, he started with a blank piece of paper. He could have said anything he wanted. He could have said states must give permission. He could have said this includes pistols but not rifles. He could have said you can't carry on horseback. He could have said anything, but he didn't, because we had just fought a tyrannical government for our very survival. Thousands of men and women were killed during that battle. Thousands more had their homes burned down, were impoverished, and sent out into the weather to make it the best they could by a tyrannical king who commanded his soldiers to literally murder their own people.
So
Because at the time, we were British.
let's bring that forward a little bit because I got a couple of questions on that. Okay, what is the purpose of the Second Amendment? Let's start with that because you're kind of laying it out, but the argument from the other side is that's never going to happen today. Our government's not out of control. We're not going to have to defend ourselves against a government or a foreign country or whatever on the streets. Why? There's no need for a Second Amendment at this point. What?
Well, that's because I'm sorry, but they don't want to define what it says. They won't actually do the definition of the words that are in it.
Oh, it's even worse than that. That would be easy to overcome. It's even worse than that. And let me bring it forward for you, like Mark says, because that's very important. 100 million, arguably 100 to 120 million Chinese citizens were murdered by their own government after the government had disarmed them. 70 million Russians were murdered by their own government, Joe Stalin and his ilk, after the government had disarmed them. Now, remember, the communists first said, pick up your arms, get your guns, come and fight. We'll, fight for freedom, fight for communism, fight for the party. But the minute the fight was over, the government said, well, you don't need your guns anymore. Life is good now.
Turn them in.
Turn them in.
Yep.
Turn them in. And then they murdered 70 million of their own people. And I could repeat that story in Cuba, in Venezuela, in Brazil to a lesser degree, in Argentina, and governments all around the world. And what is the unifying theme? They disarmed their own people first. I'm sure the people of Ukraine wish they had a Second Amendment before the Russians almost took their capital. And then their own government rethought their position and started shoveling automatic rifles out the back door of the building as fast as they could to anyone who would pick one up in order to defend himself, his family, his community, and his nation from an invader, a foreign invader. Okay, and then you have the tyrannical government that lives right in your own country. And after you're disarmed, I'll bet you the people of Venezuela wish to hell they had a Second Amendment, because once Hugo Chavez took their guns away, then he was free to murder tens of thousands of his own people. In Iran was disarmed after the Islamic Revolution. They disarmed their own people, and they've since killed arguably more than 100,000 of their own people. And if anyone thinks the United States of America is not capable of that, you're smoking crack. I mean, first of all, they let 20 million illegal aliens in who've been going around robbing, murdering, and raping American citizens since then. But the government themselves do not want you to possess the same tools that they possess in order to defend yourself when they're not responsible and can't be held liable for failing to defend you. So how is that supposed to work? Do you really trust a government that does not trust you with the same tools that they possess?
Well, we got a little bit of inkling of what the government is capable of with COVID and the lockdowns, and if you don't get the shots, and that power was abated to a degree after the last election, but they would have kept on going with it as far as you can see, and where would it end up? I think it would have ended up in the territory that you're talking about.
If we wouldn't have stood up, but people started getting smart and they started standing up against the government on the COVID and the shots and everything.
Sure. I mean, that happened, and it happened to be that we didn't need firearms to press the issue. Will that be the same next time? I don't know. And see, here's our problem. We established a government for a reason. The people in California established the Constitution of California because we, the people of the state of California, grateful to Almighty God for our freedom, that to secure its blessings, we established this Constitution. The people of the United States have a founding document called the Bill of Rights, and in that Bill of Rights, it says that we hold these truths to be self-evident, all men are created equal, and we are endowed by our Creator with certain inalienable rights. Among those are life, liberty, and the pursuit of happiness. And Samuel Adams qualified that as life, liberty, and property. And that to secure these rights, governments are instituted among men. What's government's job? To secure their rights. Oh, and by the way, the Constitution is dated, excuse me, the Declaration of Independence is dated years and years before the Constitution. So these rights are God-given, endowed by our Creator, pre-governmental, before the Constitution, inalienable rights.
So let's bring it forward. I don't want to interrupt you, but I want to kind of get on to the point of what this is about. And I think the point is this: do we have the right to keep and bear arms or not? Is it a subservient right? Is it a right that is equal to the other rights? Is it a right that's not equal to the other rights? We've got open carry, I don't know in how many states right now, Mark? 35?
29.
29?
29.
So
yeah.
29 states already have open carry. So the question is, in all the other states where they've watered down that right, do we have the right to keep and bear arms, open carry, period, according to what the Constitution has said? And is that what this case is about?
Yes, this case is about, do we have rights or don't we? According to the Declaration of Independence, we do. According to the Constitution, we do. According to the Second Amendment of the Constitution, we do. According to California's Constitution, we do. And here is our problem. The Article 3 courts, which, by the way, were established by the people in the Constitution, they don't support the Constitution, not because it is unlawful, but because they don't like what's in it. And that is a miscarriage of justice, a travesty, and courts should be held accountable because, let's put it this way, if we are supposed to respect the law, then courts have to uphold the law. They can't uphold the things in the law that they like and not the things that they don't like, because the next judge might like the things they don't like and not like the things they do like. I mean, that's why the Bill of Rights is immutable. The government has only one place where they can go to alter or redefine an enumerated right, and that is the Article 5 constitutional amendment process. And so anything else they do is unconstitutional and unlawful. And according to the Bruin Court, the United States Supreme Court, number one, the Second Amendment is not a second-class right subject to different rules than all the rest. Number two, the Second Amendment means exactly what the founders said it meant in language used so that everyday individuals could understand it. That's number two. And number three, in what the state loves to hang its hat on, it's called footnote number 9 in the Bruin case. And this is so laughable. I'll get to this as we go along. But Bruin case, and what that is one paragraph. It's not a holding of the court. It's just dicta, which is what the court calls kind of conversation after the fact to sort of explain what it is they're talking about. But it's by no means a holding of the court. And even footnote number 9 says that states may restrict one mode of carry dash concealed, provided they allow the other mode of carry, which must be open because there's only two ways to carry. And now the courts have changed that. And the Ninth Circuit is no different. They have changed that to mean that if states allow concealed carry, they can ban open carry. Well, that's not what the Supreme Court said.
So what you're saying is that the states changed the language of the decision of the Supreme Court arbitrarily?
It gets worse than that, because in the en banc panel, a judge asked my attorney, well, yeah, but what about the Frey case and footnote number 9? And my attorney said, well, funny you should ask that, because I was the attorney in the Frey case. And here's what happened. The Second Circuit took footnote number 9, states may restrict one form of carry, dash, concealed, and then they added language that was not in the Bruin decision. In brackets, they said, or open. And then they hung their decision on a footnote that they perjured themselves creating.
Now, how can they do that? They could just add or subtract whatever they feel like to suit their objective?
They cannot do that lawfully, but they did it. And here's the problem with inferior courts. The Supreme Court is the Supreme Court of the land. And then the inferior courts are the courts that Congress establishes from time to do other stuff. But the judges serve for a time what they call of good behavior. Well, the court has taken that to mean life. So they can do whatever they want, and there's no mechanism to get rid of them.
So what do we do about it?
Well, here's what we do. First, we fight in the lawfully, morally acceptable manner. I've just gone through the Ninth Circuit. I won in the Ninth Circuit. The three judges said the Second Amendment means exactly what it says it means. An open carry is constitutional, and California is wrong, and they struck the two statutes.
So
And
they're
then
saying they said that banning open carry is unconstitutional, and you won that case in the Ninth Circuit. And then after that, why are we back here where we're at right now?
because there's a kind of a do-over in the appellate courts, and it's called an en banc review. If one of the parties to the case doesn't like the way it turned out, and you're not supposed to do this because you don't like the way it turned out. You're supposed to do it if you think there's a procedural error only. Yeah, sorry, I couldn't get that word out for some reason. But anyway, but what can happen is the court can demand a rehearing by all of the judges in the circuit, and there's only one reason they do that, because they don't like the way the case turned out first time, and they want to overrule it and medicate it. So the Ninth Circuit called.
So we hit another bad spot here, Mark. So the only reason that they would stop this and go to this other bank of judges is that they don't like the decision. So they're going to overturn the decision of the Ninth Circuit. Is that what you're saying?
Oh.
Yeah. Maybe we can.
That's exactly what I'm saying.
There, you're back.
And guess what? In the Ninth Circuit of California, I'm back. Okay.
Yeah.
In the Ninth Circuit, the en banc review panel has done that 100% of the time in Second Amendment cases.
Wow.
So they overturn it. It goes back. Then there's only one avenue left to us, then, or to you, in the court case, you and your attorney, is to go to the Supreme Court. Is that it?
That is correct. And that's exactly what we plan to do. And my attorney, when we walked in the room in the en banc, there were 6 liberals and 5 conservatives. She did a very good job. We stuck to the constitutional question. Do we have rights or don't we? Does the Second Amendment mean what it says or doesn't it? And does the Bruin decision, which says if the conduct I seek is constitutional, then it is 100% burden of proof on the government to prove that in 1791 there were widespread, widely accepted regulations against open carry, and the state utterly and completely failed to prove its case on any level. So when they overturn this case, we're going to go back to the Supreme Court and we're going to bring them that question. Now, here's the thing. If they fail to accept the case, if they fail to answer that question, then in my mind, that is a breach of the contract that the people created, called the Constitution, which enshrined the Bill of Rights. Those are rights that belong to the people, not government. Governments don't have rights. Only people have rights.
So the essence. So the essence. Let me see if I can go to this and hit this again to make sure we got it clear. The essence of this case is not about open carry. It's not really about concealed carry. What this is about is, do we have the right to keep and bear arms, period. That's what this boiled down to?
Yes. I mean, the question is, do we have a right or not of anything? Do we have a right to do anything? And the point is, define what is a right. Well, a right is not a permission, and rights never require permissions, and permissions aren't rights. Permissions are revocable, they're alterable. You can do it here, but not there. You can do it if you pay money. You might be able to do it, but you can't. I mean, it's a right means that a lawful individual walks out the front door of his house and engages in a protected activity under the Bill of Rights of the United States Constitution, and no government has any authority to tell him not to or to stop. Look at the First Amendment. You don't have to go get permission to wave a sign about abortions on the corner. That's the First Amendment guarantee. You don't have to get permission to read a newspaper, and you don't have to get permission to defend yourself, your family, your community, your state, or your nation. That
And-
requires no government permission. That is a God-given right.
Unless
And
you're,
they have no right to pick and choose our rights for us.
And they have no authority and no jurisdiction to determine how we conduct those rights either.
Right.
And yet they do it every day because judges don't rule on the law. They rule on what they like and what they don't like on any given day.
So the real essence of this case is: do we have a constitution or not? Do we have rights or do we not? If you are going to enshrine these rights in a document, but nobody's going to pay attention to them, then they're really not rights anymore. It's just it's a dog and pony show.
Well, that's funny because the Bruin case addressed that. The Bruin case said the Second Amendment means what it said it meant, and no successive load of judges or legislators have any authority to alter that right, or else it becomes vapid and it's not a right at all.
Mm-hmm.
So what do you think is going to happen from this point forward as far as gathering steam and getting ready for the Supreme Court battle? And what do you think? So do you think you're going to win here at California, or do you think you're pretty sure you're going to go on to the Supreme Court? And what does that mean?
Well, look, I'm going to be a realist here. Yes, there is a mathematical chance that I could win in the en banc. And quite frankly, if California was smart, they'd push for that. Because if I won in the en banc court, it would only affect California. Now, 29 states have constitutional carry. No permission required. Any way you want to carry, you don't need to ask anybody. And a total of 45 states have some form of open carry. Whether that's a permit or like in Oregon, you don't need a permit to open carry, but you need a permit to concealed carry. So that's not really a constitutional carry state, yet Oregon does have open carry in a constitutional manner with no permit required. Now, Oregon's a funny thing because Oregon joined the amicus brief against my case, and they have open carry, but they don't want Californians to have open carry. There were 7 other states that joined the amicus brief against me that have open carry, but they don't want Californians to have open carry.
Well, it goes to, so what happens in California happens in the rest of the states. So they think if they can shore up their argument here and create a bulwark, then they can get that to start transferring to these other states, at least eventually.
Well, sure. And so if I win at the Supreme Court, all 50 states will have constitutional carry.
So,
Yeah.
so that seems like, and the odds look pretty good considering the court that we have there right now. And would they be able to actually render a decision if they take it on? Now they could. What happens if they say we
Well,
we
what's
don't?
the time frame,
well,
too,
Well,
you
what
know?
happens if they say we don't want to take the case?
Well, that's the coward's way out of this thing. And look, they get 800 requests for cert a year. They only hear about 80 cases. So they could take the coward's way out, just not hear the case.
Is there another option besides them hearing the case as far as with the amicus?
Yes, there is another option for them to not hear the case, and that is called a per decision. And Justice Thomas is he's really advocating for more per decisions because he says, we spend a heck of a lot of time in the Supreme Court protecting the rights of criminals. I think we ought to spend at least as much time protecting the rights of law-abiding citizens. And so per curiam means that they kind of sit around in the conference room and they make a decision, and then they send that decision out. California, you're wrong. That guy's right. Strike those 2 statutes. Open carry's legal in California. And then once that's done, but the thing about a per curiam decision is it's not published. So that's a really cheap, easy, quick way for them to go ahead and decide in my favor without generating a formal case or accepting a formal case or waiting 10 years to hear the case.
So there'd be no precedent that anybody would say, okay, so what good would that do?
Well, for one, California would have open carry, and the rest of the states could quote the outcome of the case. There just wouldn't be any language within the case that they could hang their hat on. But what they would say is, well, the Supreme Court said open carry legal. That's enough. I mean, I'll take, if that's the way we get it, I'll take it. We'll work on the rest later.
Okay. All right. So you're
But
gonna.
if they choose not to, if they choose not to hear this case, in my opinion, that is a breach of the contract that created our government, and the people are free to seek self-help.
And we have a bigger problem.
Well, we could have a bigger problem,
Yeah.
that's for sure, at that point.
Well, we have a big problem already. That's it.
Well,
Yeah, there's no easy way out of this if they don't agree.
well, nobody said life was ever going to be easy.
Well,
Yeah,
that's true.
That's true. Well, let's fight.
And-
Let's fight the good fight, Mark. That's what you're doing.
Because how much time does the Supreme Court have to say, yes, I'm taking it, no, I'm not taking it, or whatever? Is there a time frame on it, or, you know?
Well, no. This goes back to the federal judges and Supreme Court justices that serve for a term of life. They do whatever they want to. They could hear this in the next. They can't hear it this term. It wouldn't be heard till next year at the earliest. They could hear it in a week, or they could put it off 5 years.
So but the state could also slow walk this as well on this decision with the en banc judges and stonewall it and just play the same game they've been playing all along.
Well, the en banc is not part of the state. That is a federal court. However, they give a lot of deference to the state of California for some reason. And it's funny, they don't give that same deference to every state, but they certainly do in California.
So where it
So
sits
do they think that you're just going to run out of money? Is that it? Or try to run, ragged, that you don't have the money to go ahead and push it to that degree?
Well, I think they hope I'll die.
I guess
am
there's
pretty
that.
old.
I
think
wasn't
I'll
thinking
die.
that, but
They hope
okay.
So where the case
They
sits.
hope I'll die,
So where the
or they
case.
hope I'll run out of money.
So where the case sits right now in California, you haven't got a decision from them yet, yay or nay. Yay, you're appealing it. You're going to the Supreme Court. Obviously, if they say yes, then that's where it is. But how long do you think it'll be, or is there any way to speculate on what the time frames on that would be? And do they have to do anything? Can they slow walk it for 5 years? I mean, what?
No, yeah, I mean, really, if you got right down to it, they could slow walk until I was dead, because once again, there's no recourse for the people in a court. However, if they attempt to do that, we'll file a writ of mandamus and try to get the Supreme Court to order them to hear the case. I think it for sure, at a minimum, it's going to be months before we get a ruling on this. It could be as much as a year. I don't expect that. I expect them to rule against us. When they walked in the room, the liberals had their minds made up already. They did not want to hear what I was saying. They accepted the lies that the state told. They didn't even bat an eye at any of the lying that was going on. But I do have to say, Amy, towards the end, when she had her rebuttal period, because she was very wise and reserved 10 minutes to rebut the state's arguments. And during her rebuttal period, she hammered them. And she hammered them on the constitutional issues of, do we have rights or don't we? And does the Second Amendment mean what it says? Because the state has utterly and completely failed to prove any semblance of any part of their case according to the Bruin standard, the Rahimi standard, the McDonald, the other Supreme Court cases involving Heller and the rest of them. They have utterly failed to prove their case and have not one shred of evidence to support the ban on open carry. And you guys know it.
There's no other word for
So-
that besides despotism and tyranny. I mean, that's where you end up. And Amy is your attorney, I'm assuming.
Yes, that's the attorney.
That's correct, yes.
All right, so then,
And
go
you
ahead.
did very well. The case is under submission. I think the liberals, like I said, it's a pretty compelling case. For them to tell me no, for them to find for the state, they're going to have to do some serious lying. And they are going to have some very, 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 very tortured logic, because all of that footnote number 9 stuff that they used, and all of the Frey case where the Second Circuit changed the language of Bruin stuff they used, that is what cops call fruit from the poison tree. In other words, if you lie in court, and you get caught at it, that means everything you said is a lie because you can't be trusted. So if we can get the fruit from the poison tree argument in there and get that in front of the Supreme Court, it would be a little bit hard. In other words, the Supreme Court would have to use some pretty tortured logic not to take this case.
So the state's arguments would basically be inadmissible at that point, and you'd win by default.
But the state's arguments are inadmissible now.
I was going to say
use public safety.
that doesn't seem to come in the equation.
Yeah, they use public safety. Public safety is overruled by Bruin. They used interest balancing. Interest balancing was specifically denied by Bruin. They used Jim Crow laws. In other words, it was brought up in court that the reason California banned open carry was to keep blacks from carrying guns.
Wow.
And what the state's argument was for that? Well, yeah, Your Honor, that might have been true then, but it's certainly not true now. Okay, well, that changes the fact. Yes, Your Honor, I murdered that guy in a bar because I was really pissed at him, but I'm not mad at him now. I mean, what kind of defense is that? So quite frankly, the state's case was childish, and it was rudimentary, childish, and it was inadmissible, and they know it. But they also know that judges in the Ninth Circuit, the liberal ones, they don't like what's in the Constitution, and they rule against it every single day, just because they don't like it, not because it's the law.
Right.
And really, guys, that's the fight we're in. That's what we have to stop. Do we, the people, is there anything in the Palladium of rights that you have the ability to just walk outside your door and do without paying a tax, paying a fine or a fee, or begging someone's permission who is probably crooked themselves?
It's crazy because the liberals don't understand, like you said, with all the communist takeovers in the past, is that they end up being the first ones in the firing squad, and they're not on the and they're on the wrong end of the gun. I mean, that's what happens is because you take away these rights, you're not just taking away the rights of the guys that want to own firearms. You're taking the rights away and the ability for everybody to have any rights at all.
Yeah, that's it in a nutshell. Because look, if they can strip us of the Second Amendment, if they can find a way to make it legal for the Second Amendment to require permission, don't you think they're not going to stop at that? I mean,
yeah, it's going to be the start of it.
That's going to be the start of it. I mean, I don't know, to me, but I think being a liberal is a mental disorder anyway, and I genuinely do, because you can't see common sense. You can't see the difference between black and white. If you think black looks like white, it's okay to say white's black because I identify that.
And if you say that, you're probably a white supremacist.
Yeah.
Yeah.
But if you stop and think about it, like we in the beginning.
Here's our problem.
Go ahead.
Here's the problem for regular people. If we don't vindicate this right, then we won't be able to hold on to any of them.
That's what I'm saying. That's exactly right.
I was going to say, like you said in the beginning, you talk about these other countries that they, took the guns away and then murdered their own people and all that. If people just looked around and you go to these countries now, those people want those rights back and they can't get them back. They realize now what they gave up and they regret it. And these people here in this country aren't looking at that. Look at all the chaos that's over there now.
Yeah, I look at that Austrian woman who lectures in the United States, and she was a young lady in Austria when Hitler came in, and she said, we voted the guy in. He didn't take over Austria. We voted.
Yeah.
Yeah.
Yeah,
Well,
that's a scary part.
Well, yeah, you're breaking up again, Mark, but I think we're getting pretty close to where we got to end this anyway. I mean, any last thoughts of I don't know, can you
Well, I do know that we're looking at that to go to the Supreme Court. Of course, we hate to say it, but it's going to cost money. I mean, all of this is very expensive to do, and we need to start reaching out to the people and asking for funds. I mean, I hate to put it that way, but this doesn't come cheap at all. And we appreciate all of the money we have received and still receiving.
Yes, we do. And I thank God for the people who have donated to this, because I couldn't have done it without them. And I'm not going to be able to finish it without help. I just won't.
Well, we heard that, Mark, but you're in and out a little bit here.
There will be fundraisers coming up. Stay tuned for that while we bring Mark in. And then also to let the people know if they want to send their to donate, where to send it, which would be 1304 East Street, Suite 110 in Redding, California, 96001. And I know that we're planning a few fundraisers coming up. So stay tuned. But we wanted to get this information out to the people to let them know where the case was and where we were headed with it. Because it's been a while since we had Mark on.
We might have Mark back. Or go ahead and say something,
Maybe.
Mark. Are you there?
Yeah, I'm here. Can you hear me?
Yeah.
I'm here. Can you hear me?
Yeah, go ahead and give us some last words while we got
okay.
you, and then we'll end it.
Well, I'll tell you one thing. I'm a soldier. I've been a soldier of one kind or another most of my life, and we have millions of people buried all over the world who fought in the cause of liberty. And it is time, people of this nation, to stand for liberty on our own shores, because it's being stripped from you every single day by your state legislature and the courts themselves. And if we don't fight this,
Anyway, but
We'll get
yeah.
Mark back. Maybe we can get him in the studio or in a better connection here. But it's his iPhone 782 is not working, I guess. But I guess we're just going to end it there, and then
we just wanted to make
make sure that
let
they know where to
people know.
send the money and get involved. And I think there's going to be a couple fundraisers coming in.
Yeah, we
and
will.
We'll get that.
Stay tuned, and we'll have him back again. Yes,
Yeah, we'll
definitely.
get that information out there as soon as we have it available. Okay, so government is not reason, it is not eloquence, it is force, and force like fire is dangerous servant and a fearful master.
Till next time. Thanks, Mark.